The last chapter in this text, Chapter 10, addresses legal considerations and corrective action as related to maintaining an EMS quality improvement program. Once completed with this module, you should be able to describe the types of legal and regulatory influences on the quality improvement process, identify existing statutes and laws from various states outlining those processes that shall be utilized in the quality assurance process, identify the statutory protections for quality improvement processes protected from disclosure, outline the steps necessary for remediation and due process for quality improvement, explain the regulatory and legal structures for quality improvement, identify the legal process in the discovery phase and quality improvement issues related to civil litigation generally protected from discovery, discuss HIPAA events that indicate the need for discipline, and identify the progression of a lawsuit and the responsibilities of an EMS manager in that process. To lend perspective to this chapter, consider a scenario where one of your EMS crews was dispatched for a suicidal patient. After a discussion with the patient, the crew determined that the patient was awake, alert, and fully oriented to time, place, and event. Even though the documentation stated the patient had been drinking, a release was signed and the EMS crew cleared the scene without any treatment or transport of the patient. Approximately 20 minutes after contact with the EMS crew, the patient did indeed kill herself. The family subsequently filed a lawsuit against the EMS providers and the ambulance service, claiming the crew was unprofessional and derelict in their duties. Even before the lawsuit, however, the quality improvement team did evaluate the run as all patient refusals were reviewed per policy. The quality team had noted that the patient's drinking could have possibly disqualified her from being able to sign as a competent adult. It was also noted from the patient care report that the patient was on antidepressants. The crew was provided this feedback after the QI review. Despite this feedback, no further action was taken by the ambulance service as the crew did obtain a release. The patient met the criteria for being alert, and the patient also did not exhibit any suicidal behaviors in the presence of the EMS crew. In the end, the court ruled that the EMS crew was not negligent in their handling of the situation, as the patient did indeed appear to be competent to refuse care. Even though the patient's alcohol and antidepressant use was raised as factors in the case, the court did not see them as key issues as the patient was oriented and signed the refusal form. Looking at the totality of the quality improvement process in this case, how would the use of the quality team findings potentially affect this case? What process did the EMS agency have in place for risk management, both from a patient care perspective as well as related to legal liability? What strategies were employed to avoid judgment or legal award? What legal statutes, administrative rules, or regulations exist or could be put in place to protect EMS agencies and crews from civil liability while also ensuring accountability to a patient wrongfully harmed by an EMS agency or crew? Hopefully, you should be able to formulate answers to these questions once completed with this module. Pre-hospital emergency care is routinely administered in an uncontrolled environment that involves a considerable amount of uncertainty. Unfortunately, despite the best efforts of EMS providers, people die or suffer other horrific fates, and it is not uncommon for those patients or their families to blame the EMS providers for their loss. To begin, the last chapter talked considerably about being a quality and highly reliable organization focused on customer service. The importance of maintaining a culture of quality and customer service extends beyond positive outcomes for the patients. It also helps protect against a certain amount of legal liability, as people who experience excellent customer service are less likely to lay blame on those who treated them with respect, dignity, and kindness. Thus, one way to reduce potential litigation is to simply be nice to your customers and stakeholders. As this only takes you part of the way, though, and will not discourage all lawsuits, the next best defense is to be competent, which, ironically, is also a tenet of a quality organization. Despite an EMS agency's best efforts to build and maintain a culture and environment of quality and customer service, lawsuits are still possible. With this in mind, every EMS leader and manager should be familiar with the laws in their jurisdiction that encompass quality improvement activities. Within this particular module, we will look at legal protections afforded to the quality improvement process, the authority or mandate to perform quality improvement, and due process requirements when quality improvement activities involve possible punitive actions for an employee. Please be aware that while quality improvement committees are involved in numerous facets of maintaining quality within an EMS agency, the majority of the discussion in this chapter will focus on quality improvement activities related to providing patient care. To begin, while providers are often concerned about the liability associated with conducting quality improvement activities, there is commonly more liability associated with not having a robust quality improvement process. Quality improvement within EMS is often mandated by accreditation bodies and state law or regulations. Within Wisconsin, DHS 110.47 sub 4 requires every EMS provider organization to have at least one quality assurance designee who is responsible for managing patient-based quality improvement processes in collaboration with the service medical director. We will delve a little deeper into liability protection for quality improvement activities in just a little bit. For such a quality improvement system to be successful, the system must be proactive. EMS agencies that truly support a just culture recognize the value intrinsic within the self-reporting of errors and near misses. In larger services in particular, a quality improvement manager or team cannot possibly know about every single error or near miss without being affirmatively notified about them. By supporting a just culture where employees feel safe in reporting such occurrences, the quality improvement manager or team can evaluate causes for the error or near miss and then take corrective actions to prevent future similar occurrences throughout the organization. While it is true the cause may ultimately be provider-centered, as already discussed in our other modules, the error or near miss is usually associated with a system or procedure issue. By reporting the occurrences internally, it gives the organization an opportunity to be proactive and improve training, systems, or procedures throughout the entire agency to improve services and patient care. By maintaining a thorough and comprehensive quality review program, an EMS organization is actually taking affirmative steps toward preventing or mitigating a lawsuit. Increasing the quality of care provided by an EMS organization through initial provider training, continuing education, ongoing experience, and quality improvement reviews is important for obvious reasons. The quality improvement piece is often overlooked, but it is just as critical to support the provider's ongoing growth and learning within the profession. If a mistake is made, the provider needs that feedback to ensure he or she or someone else does not make the same mistake down the road. Because quality improvement activities are key to this individual learning and organizational development, such activities are typically not only required by law, but they are protected by law as well. So, what do we mean when we say quality improvement activities are protected by law? Consider for a minute what we already said about a just culture and the reporting of errors. One of the primary functions of a quality improvement process is to identify errors that occurred or could have occurred given the circumstances and learn from them to avoid similar errors in the future. With that in mind, what do you think the effect would be on quality improvement systems if an attorney could call up an EMS agency, ask for their quality improvement records, and then use those records to identify patients who suffered harm because of the error? If that was the case, healthcare providers would have an incentive to not uncover errors at the risk of discovering something bad that no one else knew about or would have found, leading to a potential lawsuit. That is not what we want as a society. We want medical providers to learn from their mistakes and not make them again. For that to happen, those medical providers, EMS included, must have the opportunity to discover their own faults and take proactive steps to fix them. Therefore, it is imperative that healthcare quality improvement activities be protected from legal discovery and used for internal purposes only. To support this need, many states have laws that prohibit access to or exempt quality improvement results from discovery and litigation, meaning plaintiffs cannot use an EMS agency's own quality improvement process against the agency in a lawsuit. One way laws are designed to protect healthcare quality improvement activities is by providing immunity from litigation related to participation in those quality improvement activities. Such provisions protect those who are conducting the review from liability for their acts or omissions as a part of that review. Within Wisconsin, State Statute 146.37, sub 1G, provides that no person acting in good faith who participates in the review or evaluation of the services of healthcare providers or facilities is liable for any civil damages as a result of any act or omission in the course of such review or evaluation. An act or omission includes censure, reprimand, or other disciplinary action against a healthcare provider or facility. To go a step further, additional provisions within the law establish a presumption of good faith, meaning that it falls upon the plaintiff to prove the reviewer was not acting in good faith when participating in the review or evaluation, which can be a very difficult threshold to overcome. In case you were wondering, EMS providers are indeed included in the definition of healthcare provider within this law. Another protection provided by law for healthcare quality improvement activities is the protection of quality improvement documents from discovery or use in litigation. Every state is somewhat different in how these laws function, so the textbook recognizes some common criteria to ensure quality improvement documents are immune from discovery. First of all, protected documents must analyze the care provided and will commonly also evaluate the quality of that care in comparison to standards, protocols, or other recognized or acceptable thresholds. Documents that are administrative in nature, which are those that commonly reflect the routine operations of a facility or service, are not protected. Essentially, protected documents are those that deal with distinct care concerns that might arise from process or other issues. Protected documents are typically work products from the Quality Improvement Committee or team that specifically address quality issues. Again, administrative documents produced during routine operations do not necessarily meet this threshold. Generally speaking, all quality improvement documents should be created using the procedures defined in law for each document's specific use. Such documents should be stored in a single, secured filing location. As protected documents typically must be a work product of the Quality Improvement Committee or team, the group should have a mechanism by which committee or team reports are generated, and the entire committee should participate in the creation of these reports. For events requiring an incident report, the Quality Improvement Committee or team should be notified by a witness to the incident. The Quality Improvement Committee's report should describe the incident and include any helpful information that will assist the committee in the review of the incident. Each committee member should sign the report once it has been reviewed, discussed, and processed. Within Wisconsin, State Statute 146.38 addresses the confidentiality of information related to quality improvement activities. This statute addresses both those who participate in quality improvement activities as well as the records or documents generated as a part of the process. Those who participate in quality improvement activities are prohibited from disclosing information related to the incident or occurrence report or subsequent review or evaluation of the circumstances surrounding the report. Any records or conclusions generated as a result of a quality improvement process investigation, inquiry, or proceeding are prohibited from being used in any civil or criminal action against a healthcare provider. This includes the original incident or occurrence report as well. If someone violates these protections for any reason other than a good faith mistake, that individual can be civilly liable to any person harmed by the disclosure or release. To go one step further, these records, if shared with a state administrative agency for the purposes of quality improvement, are exempt from inspection, copying, or receipt under Wisconsin's open records law. There is also case law that recognizes that quality review information provided to accrediting bodies or other related associations is considered peer review, thus entitling those shared records to the same protections. Wisconsin law does permit some disclosures in certain circumstances, but the depths of that law is outside the scope of this particular module. Generally speaking, the Wisconsin law governing the protection of quality improvement activities by EMS organizations is fairly robust. One additional clarification to be made is that those participating in the quality improvement process may still testify as to events or accounts of which they have personal knowledge outside of the quality improvement process. Also, using a document such as a patient care report within a quality improvement process does not then make such a document protected under the process. It is the work product of the committee and process that is protected from discovery. Routine administrative records, such as a patient care report, and referenced resources are not protected from discovery or open records requests. Another interesting facet of quality review is that of employee discipline. While robust quality improvement systems perform root cause analysis and seek to find system and process issues that explain the occurrence of errors, there are unfortunately cases where the error does rest with an individual provider or crew. In such cases, discipline may be warranted. Before such discipline is determined, quality improvement committees and medical directors must ensure a full investigation is performed. Proverbial knee-jerk reactions should be avoided. Feedback should be collected from everyone involved in the incident, and all records related to the patient care provided should be included in the process. Many states give EMS medical directors the right to limit the practice of those EMS providers under his or her direction. Within Wisconsin, the very definition of an EMS medical director delineates duties to be performed, which includes the supervision of EMTs and reviews of EMT and service performance. EMS providers within Wisconsin also function underneath the medical director's physician license, and the physician must approve the credentialing of an EMS provider with his or her service before the licensed provider can run with that service. Problems have been known to arise, however, when a medical director is used as the enforcement arm for employee discipline. At the outset, public employees have due process rights that attach to their jobs once a probationary period is completed, if such a period exists with the employer, and simply using the medical director to limit or remove the EMS provider's credential with a service in lieu of a formal discipline process may very well violate those constitutional due process rights. Keep in mind as well that these due process rights often recognize that the discipline must be commensurate with the offense. If a collective bargaining agreement is in place, it is not unusual for terminations to be prohibited unless they are for cause, and a single isolated incident may not be enough to establish that just cause, depending on the facts. Private employees do not have the same protections as public employees, but services must still be concerned about discipline and terminations based upon quality improvement activities and medical director involvement for several reasons. The first is that such discipline or terminations could be seen as precursors to unlawful discrimination, depending on the circumstances. Additionally, and probably more importantly for all EMS organizations, whether public or private, the purpose of quality improvement activities is to do just that, improve quality within the organization. One way to do that is to maintain a culture of quality and service within the organization, which includes fostering a just culture and promoting an environment that supports self-reporting and a robust quality improvement system. If such a system is routinely utilized as a precursor to discipline or termination, employees will be less apt to self-report out of fear of discipline or termination, and the organization's culture of quality and service will rapidly erode. As we have been discussing lawsuits related to patient care and quality improvement activities, it is probably prudent to have a quick overview of the legal process. Essentially, when one person or entity is harmed by another person or entity, that harmed person may seek recovery for damages suffered against the alleged responsible party. The civil process, as opposed to the criminal legal process, typically starts by the harmed person or entity contacting an attorney for assistance in filing a lawsuit. Although a private person or party may file a lawsuit on his, her, or its own behalf without the assistance of legal counsel, the process can be convoluted and daunting, not to mention a knowledge of the applicable laws is helpful in sustaining a successful lawsuit. The person or entity starting the civil lawsuit is known as the plaintiff. It is the plaintiff who alleges a loss or damages due to the actions of the person or entity he, she, or it is suing, the defendant. Within the original pleading, the plaintiff provides facts, elaborates on the damages suffered, and makes a claim for legal or equitable remedy from the defendant or defendants. Once the defendant is served with notice of the lawsuit, the defendant then has a specific period of time in which to file a response with the court. The response gives the defendant the opportunity to ask the court to dismiss the lawsuit, to include other possible defendants through an impleader motion, to provide a different interpretation of the facts, or to make any counterclaims against the plaintiff. Assuming the lawsuit is not dismissed, the process can then be tracked through a few milestones. The first was already discussed, which is the start of the litigation. This is a phase where the plaintiff files a complaint with the court, serves the defendant with the complaint, and the defendant files a response. After that initial phase, the discovery phase begins. This is the most lengthy part of the lawsuit and typically the most expensive as well. Within this phase, both parties perform fact-finding, which may include obtaining testimony from witnesses and expert witnesses. In some complicated cases, the discovery phase may take years. At some point, however, both sides have all the information they need to make a decision as to whether or not they want to go to court or work on a settlement agreement. If neither party wants to back down on their claims, the parties prepare for and participate in a trial. Once all evidence is presented and the arguments are concluded at trial, the court will then render a final judgment on the matter. Depending on the facts involved in the case, if there was any related criminal proceedings, the lawsuit may refer to those criminal proceedings as well. Throughout the process, attorneys are working on strategy and often file motions and raise objections to be considered by the court. While everyone simply assumes cases are always appealed by the losing party, that is not necessarily typical, as it is not possible to appeal the final determination of the jury. That which is appealed is the application of law to the case itself. Depending on the nature of the law that was alleged to have not been followed correctly by the court, it may also be necessary for the attorney to object at the time of the alleged impropriety to be able to reserve the right to appeal the decision later based upon that incorrect interpretation or application of law to the facts in this particular case. The need for strategy and knowledge of the legal process are the primary reasons why parties to a lawsuit really do need representation by an attorney. A lay knowledge of the law will not be enough in most instances to ensure the best opportunity of winning an adversarial lawsuit. As far as EMS providers and agencies are concerned, it is not uncommon for EMS providers to testify in civil lawsuits without being parties to the lawsuit. When that occurs, it is typically through a deposition in the discovery phase of the litigation, although it may be necessary for the EMS provider to also testify during the actual trial, depending on strategy employed by the attorneys to the case. If the EMS providers or EMS agency are actual parties to the lawsuit, then they are involved in all steps of the litigation process. WCTC's EMS Leadership and Management program has a course dedicated specifically to the legal aspects of EMS system management and leadership, so we will not delve much further into the legal process in this particular course. This brief overview should hopefully be enough to help place the quality improvement process into context within the realm of legal exposure and liability for an EMS service. Another reality of litigation for EMS agencies lies within the disciplinary process and the threat of litigation from employees who feel they were unjustly wronged by their employer. In this respect, there is plenty of case law that helps establish a clear path for employment actions based upon quality improvement activities. As mentioned briefly already, employees are typically owed due process rights with respect to their employment. The reason the word typically is used is because public employees, those employed by a governmental entity, have greater due process rights and protections than those employed by a private company or entity. Essentially, due process is considered to be the legal principle that recognizes the government must respect all of the legal rights that are owed to a person. If the government also employs people, those due process rights carry over into the employment relationship. Outside of the employment relationship, due process also limits laws and legal proceedings so that judges, as opposed to legislators, define and guarantee fundamental fairness, justice, and liberty. These due process requirements also extend to governmental proceedings that impact EMS licensure. Before an EMS provider can have a license to practice revoked by the state, there must be an opportunity for a hearing. Adequate notice of the hearing must be provided, and there must be a neutral magistrate, often an administrative law judge, unaffiliated with the regulatory body seeking to take action against the provider's license. This is referred to as procedural due process. There is also something known as substantive due process that essentially looks at the entirety of the process and the end result to ensure the process was not only followed correctly, but the end result is consistent with the underlying principles and rights defined within the Constitution. Essentially, all governmental intrusions into a fundamental right or liberty must be fair, reasonable, and in furtherance of a legitimate governmental interest. As far as EMS providers are concerned, the government does indeed have a legitimate interest in making sure EMS providers are safe, effective practitioners for the benefit of the public as a whole. Therefore, so long as procedural due process is followed and the action against the individual's EMS license is reasonable and fair, the substantive due process requirement in the law will be satisfied. From a due process standpoint, public employees typically enjoy a property interest in their jobs. So long as the public employee has a reasonable expectation of continued employment, a property interest attaches to the job, and the government, the employer in such a case, cannot deprive the employee of that property right without due process as guaranteed by the 5th and 14th Amendments to the Constitution. This makes the right to earn a living a legal consequence that must be considered within a trial or arbitration hearing for public employees. An important facet to recognize within protective service disciplines is that probationary employees do not yet have a protected property interest in their jobs, which means they can be terminated at any time for virtually any reason, so long as the reason is not illegal, such as an intentional discrimination based upon a protected class, such as age, race, gender, and so on. To ensure proof of compliance with due process requirements in employment decisions, governmental employers should ensure adequate documentation is maintained of all disciplinary proceedings, which can include audio or video recordings of any proceedings. Detailed training records, periodic reviews, and discipline records are also essential. To clarify, these due process requirements do not apply to private non-governmental employers. The only requirement for private employers is that employment decisions are not based upon illegal reasons. The textbook also mentions something known as a 1983 lawsuit. This refers to a lawsuit based upon 42 U.S.C. Section 1983, which establishes a private action against public officials for deprivation of protected rights. Maintaining detailed personnel training records and evaluations, along with standard operating procedures and documented corrective actions through a quality improvement program, is important in defending against such actions. Obviously, while quality improvement activities enjoy some protection by law and EMS agencies want to maintain a just culture that includes quality and service, there are some scenarios where EMS providers must still be disciplined or maybe even dismissed based upon the findings of a quality improvement program. With that in mind, providers should not compound a mistake by covering it up out of fear of discipline. Errors should be promptly disclosed and documented on the run report. Corrective actions should be taken, which often includes remedial training or continuing education. Failure to report such an incident is definitely grounds for discipline, which may even include termination depending on the particular facts. Something like that also sends a message that reaffirms the agency's commitment to fully supporting its quality improvement program and the need for providers to self-report when an error occurs. Another question that is often raised regarding the legal implications of healthcare quality improvement systems is exactly what patient information can be utilized in the quality improvement process given the applicability of HIPAA. The answer is actually very simple, in that HIPAA recognizes the need for system quality improvement activities and allows the disclosure of protected health information for health oversight activities, which includes audits or investigations necessary for the oversight of the healthcare system. As is always good practice, the inclusion of protected health information must be limited to what is minimally necessary to accomplish the task at hand. Therefore, when evaluating a case, including the patient's age, gender, race, medical history, and other data is probably pertinent in most situations, whereas the inclusion of the patient's name or date of birth may not be necessary to perform the quality improvement function at hand and, as a result, need not be released. Essentially, EMS and hospital personnel must effectively communicate to further the continuity of quality care, which also means there is no HIPAA prohibition against a hospital providing patient outcome data to an EMS agency for the purposes of quality improvement activities. For years, it was not uncommon for hospitals to refuse to release information to EMS agencies citing HIPAA concerns, but those concerns are unfounded as HIPAA allows those disclosures for the benefit of improving the healthcare system for future patients using that system. As part of a robust quality improvement program, it is not unusual for services and agencies to utilize a peer review process to make the process less threatening to the EMS providers while also ensuring an honest and aggressive critique of the care provided by those within the agency who provide such care themselves. Regardless of whether a quality review process is conducted by a team of managers or peers, the process is still protected as we discussed earlier. One wrinkle that exists in some areas is that if someone seeks to obtain documents utilized within a quality improvement process, the burden of proving that those documents are protected from discovery falls upon the entity claiming the privilege. Thus, it would typically fall upon the EMS agency to prove to the court through sufficient facts that privilege exists in the particular case. Part of the reason for that burden is that the requesting party does not have sufficient knowledge of the document to affirmatively prove to the court that the document should not be considered confidential. Admittedly, there are some documents that may not be confidential within the process, such as the original patient care report or resources used to help identify the standard of care that should have been applied in the case. For the plaintiff to try to differentiate between those documents when they do not know what documents actually exist and what they contain would essentially exclude everything from discovery, even if the particular document is not privileged. As with most of what has been discussed within this chapter, EMS agencies are encouraged to consult with legal counsel with regard to their quality improvement activities, especially if a request for production of documents is received. In 2010, the Field EMS Quality, Innovation, and Cost-Effectiveness Improvements Act was introduced in Congress to ensure high-quality, cost-effective EMS systems across the country, with mandates for readiness, preparedness, medical direction, oversight, and innovation through medical care. The bill was also designed to implement and evaluate system-wide quality improvement initiatives. Despite some industry support for the bill, it was never passed into law and wound up being reintroduced in 2013 as the Field EMS Modernization and Innovation Act, which was also never passed. Regardless, quality improvement activities were recognized as important in the bills, and other national-level documents, such as the EMS Agenda for the Future, do indeed include provisions for quality improvement initiatives. As more emphasis is placed on our country's healthcare system, along with the funding challenges associated with that system, it is anticipated that EMS will continue to be included in and impacted by those discussions. Wisconsin already requires EMS agencies to submit patient care records to the ward's database system, and many other areas of the country are also seeing EMS patient care reports included as a part of the patient's electronic health record. Incorporating data elements of EMS patient care reports into patient electronic health records is one of the final steps in integrating EMS into the larger healthcare system. Looking ahead, legislation related to affordable health care and Medicare/Medicaid will eventually facilitate a different type of reimbursement for EMS based upon quality, outcomes, and efficiency. Rather than simply paying for services provided, the federal government is moving toward payments based upon the quality of the care provided. As that transition in funding begins to incorporate EMS, quality improvement activities will serve an even more prominent function within EMS agencies. Beyond the funding considerations on the horizon, quality improvement should ultimately be about providing the best possible care to our patients. By ensuring a culture of quality and service, EMS agencies will be well prepared to accommodate a funding mechanism based upon quality versus quantity. Returning back to the scenario presented at the start of the module, the quality improvement team will need to identify how often a complete set of vital signs were obtained, assessment of level of consciousness was completed, and potential for suicide was evaluated. The documentation of alcohol consumption was definitely a red flag that there could be concerns about the patient's overall capacity to consent to or withhold consent for medical care and treatment. If the patient was unable to accurately answer questions about her name, location, time, and events, that would have been indicative of a lack of capacity to make those vital decisions regarding her personal well-being. Therefore, a person with impaired judgment from drugs or alcohol must be evaluated to determine competence to refuse care. Failure to do so increases the risk of a potentially negative outcome. Documentation of that assessment must occur every time. Patient and witness signatures, when available, should also be mandatory documentation, and the level of orientation of the patient must be documented before a refusal is signed. This and other issues would need to be addressed in the quality review of this particular case, and the service will also want to ensure it continues to flag patient refusals for quality improvement evaluation, as these types of runs pose a significant risk to not only the service itself, but also to the patients it serves. As mentioned before, that is why quality improvement activities are so important. It is not necessary to be bad in order to improve, and even great services continue to pursue ongoing improvement of their systems and processes in the hopes of incrementally increasing the quality of care and level of service provided to patients over time. Legal ramifications aside, supporting a strong quality improvement process is the right thing to do. To conclude, most states have some form of mandated quality improvement or reporting for EMS, and Wisconsin is no exception. Quality improvement programs need proper laws, regulations, and administrative codes in place to protect and support the process, and we do indeed have such laws in Wisconsin. Such confidentiality promotes honest efforts to improve EMS care. Beyond those legal protections, EMS services must work to ensure that quality improvement processes do not create a culture of fear, as the most effective systems support a just culture based upon quality and customer service.